Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host. Hello again. Another Saturday is here with us, and we're so privileged to have you around. So we bring you The Community and the Law. It's live on BWTV at BWF Solicitors and at BWTV, both on Facebook and YouTube. My name is Oreku Frimpong. This afternoon, I'm bringing you a very interesting discussion. You know, the family is one unit that we all cherish. Especially when we have children in the family, we're so happy. Some say it's a gift from God. Some say that it's a blessing that we need to have children. And when we have more than one, it's always a joy. But sometimes things go wrong. And when it is that we would have to split up and also look at the responsibilities we have towards the children, it becomes a difficult matter. This afternoon, we're going to look at what the law looks at that situation and also what we can do. And then there's a very interesting angle to this whole thing. And I'm asking the question, can a parent who is not listed on the child's birth certificate apply for child arrangement order? We'll be looking at what child arrangement order is, who go into the arrangement, who supervises that, and the rest of it. Tonight, this afternoon, or today, I should say, we are privileged to have a mother, a lawyer, and a friend to take us through this very lovely discussion. And it's no other person than the partner of BWF Solicitors, Lawyer Eunice Achampong. I know you're excited, so let's get into this together.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello again, and I'm so excited to have you around. I'm looking at the comment section on Facebook and at YouTube, and I see people liking the page, sharing, and the rest of it. Thank you so much. Welcome to another edition of the Community and the Law, brought to you by BWF Solicitors and Trusted Partners when it comes to the law. BWF Solicitors, they think about us, they work for us, they help us, especially when it comes to immigration matters. So I'll be inviting you, first of all, to visit BWF Solicitors for all your legal matters. They are on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters in North London. You can call them on 0208 493 7340, 0208 493 7340, or those in Ghana, you can call 055 589 5959, 055 589 5959. In emergency situations, you call the UK number 077 127 61884, 077 127 61884. Remember, they are on the 4th floor of the Inner House, 214 to 218 Tottenham High Road, Seven Sisters, North London. They work Monday to Friday between 9:30 in the morning and 6 p.m. So make sure you have time and visit them, or you can call and book an appointment and go to visit them or send them all your concerns. BWF Solicitors can book an appointment with you and meet you over the weekends. So if you do not have time Monday to Friday and you want to have an appointment over the weekend, just call, book, and they'll make an arrangement for you. Now, if you are an organization, association, more than 20 people, and you would want to have the public outreach they do, you can invite BWF Solicitors and they'll come over and help you as well. Now, those of you who have been following this program, this year I have told you in 2026, we'll be having a live studio audience, and you may be one of them. So keep sharing, keep staying with us, and keep enjoying the show and calling people to enjoy as well. And when it is time, we will bring a handful of you into the studio and you have a live with the lawyers themselves. Okay, now let me quickly go down to the comment section and see those of you who are there, and I will quickly welcome you before I go on to bring on my resource person and guest. Sandra Fraser starts off and says, welcome to our social media program. We're thrilled you are here. If you find our content helpful, please don't hesitate to share it with your network. Your shares help us reach more people and bring together and build a stronger community. Thank you again for joining us. So yeah, Sandra, thank you so very much. I know when you go onto the page, you will see that she's listed the telephone numbers, and we'll be telling you how to get your transportation arrangements or your connections to get to BWF solicitors. Thank you, Sandra. God bless you. We do really appreciate you. And as Safo says, please share when you join. Thank you very much, Ade. You also turned out to be one of our very regular listeners and contributors. Thank you so very much. Mami Ndabozo, good evening to you as well. Mami Ndabozo, thank you for joining. We have others who would be coming. I know definitely I will be calling people to come in and join the class and the rest of it. Sandra has gone on to YouTube and put up the same message. Yes, welcome to our social media program. We're so thrilled to have you. Of course, your shares help us reach more people. Thank you so very much. And I think before I go on, there is uh, this culture that we have that people appreciate what BWF Solicitors is done for them. And I have one from Harriet that says that a huge thank you to Uncle Bernard and the entire team, especially Emmanuel and Piao, for their hard work, professionalism, and genuine care. I am extremely grateful for everything they have done and would confidently recommend that you patronize their services. Anyone who is in need of any immigration or legal advice, go to BWF Solicitors. And with that, Auntie Eunice, good afternoon.
Good afternoon, Oreku. I hope by God's grace you're doing well.
I am so very well. Let me wish you a happy new year because this is the first time I'm
Yes, it's
really
true.
having an interaction with you in this year.
That's very true. Happy New Year to you too. I mean, hopefully we'll see more of each other this new year.
I know definitely. And uh, viewers, if you see that smile, it's full of all the good things for 2026. So I would invite you to visit BWF Solicitors and you get smiles and more welcoming like this. I have always said unto you this that you are the only Ghanaian legal firm that supply chocolates. And I don't
Of
hesitate to
course.
pick up my bar anytime I enter the building. So I urge people to come in and do that. Yes, Harriet has said that she's grateful for the service she's enjoyed from yourselves. And it's mentioned Uncle Ben and Emmanuel Ampiao. Let me ask again, when comments like this come, what does it mean to yourself as a professional and as a member of a family?
I think for us, because we work as a team,
Mm.
it's always, should I say, fulfilling when we see that clients are also content with the services that we are providing for them. And Emmanuel Ampiao is one of our colleagues back in our Ghana office. And so he communicates with clients mostly through telephone and through our, should I say, indirect social media handles. And so for a client to say that she is truly satisfied with the service that was provided, even without seeing the person who is working with her, it is amazing that they have had a successful outcome, and it actually boosts our ego to make sure that we do the very best we can for all the clients that come into contact with us. And so, Harriet, we're very pleased that your application has been successful, and we hope that you do recommend others to also come and experience the same service you received.
Well, some of the things that you do is to help people get empowered when it comes to one understanding the law and going about all the immigration matters, especially. And one of the things we do is to come on the program Thursdays, Fridays, and Saturdays, and we help them with information. We help them to get their questions, answers, and the rest of it. And also, you provide us with updates, like we're going to have as part of our nugget. Loyalists, Section 94 of the Nationality Immigration Asylum Act of 2002 says that the Secretary of State has the power to certify asylum or human rights claims as clearly unfounded, meaning they lack merit, thereby preventing the claimant from bringing an appeal while still in the UK and enabling quicker removal. The section talks about the fact that this certification can happen if the claimant is from a country listed as safe, that is a designated state, or on a case by case basis where the claim is deemed factually unfounded, often leading to an appeal only after leaving the UK or through a judicial review. So, my question is, if somebody says that, well, I'm seeking asylum and I am basing it on the fact that where I come from is not safe for me to stay, either from political angles or from familial angles and all the rest of it, um, it could be denied. But then, if it's denied and the person has a case to press on, this is saying that they may have to leave the country before they do that. Me, I'm running away. I've come to seek safety or haven from your end, and you're sending me away before I can appeal. Explain and please put more light on this one for us. What is it really talking about?
Okay, so most people who would be making an asylum claim would be making an asylum claim on the basis that they're fleeing for their lives due to some sort of risk to their life or some form of um, fear to being persecuted wherever they are coming from. And let me just give us an example or a scenario. So let's say I'm from Sudan, and because of everything that's going on, I've decided to flee my country. So I've come through all the way to Greece, and I've tried to make my way to the UK after traveling through Europe to get here. And when I get to the UK, I put in an asylum claim to say that I am fleeing persecution from my country. And so, as soon as I do that, because the UK is also a signatory to the Refugee Convention, and we have a number of European countries that are signatories to the 1951 Refugee Convention. And the signatories usually have to abide by the convention and the laws that were placed in there. And so, as a signatory, the UK would usually take on board any refugee that comes to the UK to seek asylum, provide them with the best support that they can give to them, and make sure that they are well looked after. If a refugee comes to make a claim and then they say, well, I'm fleeing from Sudan because of A, B, and C, and like you said, it could be due to race, it could be their religion, it could be fear of being part of a small group which has its own beliefs or political beliefs. And so obviously, in terms of sexual orientation as well, some people may also have different sexual orientations and they are fleeing because of the fear that they will be persecuted. So, if for any reason somebody is fleeing their country due to any of these reasons, and they have come to make a claim in the UK, for instance, the UK will have to look to see if their claim is founded. Is it true? Is it genuine? If the UK assesses their claim and says, okay, we think that you have a genuine story here, we would like to offer you asylum, then that's good for the person who's coming. But if the UK says, hey, when you were coming, you went through all these other European countries, and some of them are signatories to the 1951 Refugee Convention. Why didn't you seek asylum in those countries, but you came all the way to the UK to seek asylum? And if they believe for any reason that you could have sought asylum from any one of those countries that are signatories to the convention, then they can say that your claim is clearly unfounded because you are coming from a safe country. So
Mhm.
it could be that the person came from France before they entered into the UK.
Okay.
And we all know that France is a safe country. Or they came from any one of the European countries which is a signatory to the Refugee Convention.
Mhm.
Those are safe countries. So if they are safe countries, why did you not seek asylum in those countries before you came to the UK? And so when it is said that the claim is unfounded, they are trying to say that you are coming from a country where you could have sought asylum because it is a safe country, and therefore the best thing for you to have done was to seek asylum in that country before trying to make your way to the UK. And obviously, if you were coming to the UK for any other reason, you would need some sort of visa to come in, just as any other tourist would come in. But on the basis of our nugget for this week, if someone makes a claim and the claim is assessed as clearly unfounded, it is saying that that person's right of appeal would be removed because they went through a safe country before they came into the UK, and they could have sought asylum from that country before entering the UK. And therefore, um, the Secretary of State has every right to certify that claim as unfounded because they didn't do what they were supposed to do in that designated country before coming to the UK.
So my concern earlier on was that yes, France, for instance, in the scenario you've given, France may
Yeah.
be a safe country, and you've come through that, and now they're sending you out of the UK, possibly to France, and
Yes.
then when you're out there in France, you can make an appeal against the decision that your claim was unfounded. I go to France, I don't have a leg to stand on. How am I going to make an appeal then?
So in this case, you would have to try and seek for judicial review.
Okay.
So if you believe that you went to France, there was no way that you could have sought for asylum in France because maybe they have put certain restrictions in place. Therefore, it was very challenging for you to apply for asylum.
Mhm.
Then you can obviously put in a judicial review whilst you're here in the UK, because that is an alternative if you do not have a right of appeal. And so if you believe that, well, I entered into a safe country, the procedural rules there did not afford me to make an asylum claim as I should have, and that's why I had to come to the UK. Then, of course, the upper tribunal, where we usually send all manner of judicial review claims, will have a look at it. And if they believe that you should have permission for the case to be heard, they will hear the case and then they will deal with it accordingly.
Right. Well, as I mentioned earlier on, this is from Section 94 of the Nationality, Immigration and Asylum Act of 2002. And it talks about the power of the Secretary of State to certify asylum on human rights claims as clearly unfounded, meaning they lack merit, and thereby would prevent the claimant from bringing an appeal while still in the UK and enabling quicker removal. The same act, section of the act talks about the certification happening, and when it is from a claimant from a country listed as safe or a designated state or on a case by case basis where the claim is deemed factually unfounded. Often it will lead to an appeal only after leaving the UK or through a judicial review. And I asked that question, and lawyer Eunice has really explained that to us. So, uh, yeah, did you want to add something, please?
No, not really. But I
Okay.
also wanted to just say quickly that, of course, when it comes to cases that are through the asylum claim, most people think that, okay, maybe it's only through asylum that I would be making such a claim. But there are also human rights claims that are also similar to people who fear that they may undergo some form of persecution. So it's not just asylum claims that may warrant a fear of persecution, but some people may be going through, should I say, challenges where their human rights are also being challenged, and they may also fear that their lives may be at risk. So it also applies to human right claims as well. Yeah.
Okay. So then I have this scenario. Let me put it out. And maybe I'll ask my viewers and listeners to help me advise this very particular person. Her name is Yababy. Yababy is an overstayer in the UK. She made a private life application on the grounds that leaving the UK will bring her hardship in her home country, even though she is not lived in the UK for 20 years. Her application was refused, sorry, and certified. So it goes with the Section 94 of the Immigration Act of 2002 and says that the Secretary of State has a right to certify that it is unfounded. So, my people, let's see what advice we can give to Yababy. Can we say that Ya is open to removal from the UK, therefore she can leave voluntarily? Can we say Ya can seek judicial review to challenge the refusal decision? Can we say that Ya cannot appeal because her refusal decision has been certified? Or we can say that, well, all the above, 1, 2, and 3, apply. So she can go through all the 3, or you could probably say none of the above. Think about it. If I go back to Lawyer Eunice, you answer it. I want to test whether you have really picked up a good understanding of that. And when we come back later on to it, I will ask for your answers. You can leave them in the comment section below, either on Facebook or YouTube at BWF Solicitors and at BWTV UK. Text your answer also to 07399 208468. You can do that on WhatsApp as well. The lines will be active very later on when we have gone into our main topic and discussed that. And that will be 0208 493 7345. We're live on BWTV, and I'm asking the question: can a parent who is not listed on the child's birth certificate be a party to this arrangement for child custody and the rest of it? We will be looking at child arrangement order, what it is, what brings that about, who are part of that arrangement, and who supervises the order, and the rest of it. Lawyer Eunice Champon will be leading that discussion right after this.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for staying. In fact, if you have really stayed from the beginning up to this point in time, I don't expect you to like the page and share, because you have benefited, one, and two, you have kept us motivated to go on. Can a parent who is not listed on the child's birth certificate apply for child arrangement order? What is that? Lorenas, good afternoon once again. Thank you for making time for us. I know Saturday afternoons are very um, of a very high value to parents, especially when it comes to motherhood. But you have made time for us, so we really appreciate that. But let's get into this child arrangement order. What is that, and what brings that about, really?
Okay, so a child arrangement order, I would say, is an order that is specified under our Children's Act of 1989, and it literally gives a parent or a relative of the child the right to reside with the child, or it could also uh, have some prohibitions or some prohibited steps. So it might prevent the parent or the relative from taking the child outside of the country, for instance. And then it also makes arrangements where, for instance, a parent or a child, I mean, parent of the child or a relative of the child may also um, make sure that they are making provision in terms of where the child will permanently reside. And so most people will say, in terms of child arrangement orders, um, it really simply put, it's an order by the court where the child is given that home, that safe home, or that safe place with that parent or with that family member who can then reside with them up until the age of 18, when they can make their own decision as to where they would reside.
So, if I get it right from your explanation, this order could be not necessarily for partners, but it could be a member of the family outside of the immediate circle who could be in that arrangement and giving certain powers to make decisions for their child. Could I be right if I said so?
Yes, and it's not limited to just the parent, like you said, because
Mhm.
there are other family members who could apply for the child arrangement order if it is deemed that the parents are unable to care for this child.
Okay, right. So, could I also look at it from this point that there is a misunderstanding between the partners, and one would want to take full responsibility of a child, so would go for such an arrangement from the court? Could I also look at child arrangement order from that angle?
Yes, and I think a lot of the time where a couple have come together, they've had a child or a couple of children or more than two children, and they haven't married. So, in most situations, if the couple were to be married, then both of them will have parental responsibility for the children automatically. But here we have a couple, they've lived together, they've had the children, but they're not married. And
Mhm.
so usually the woman may choose to put the father's name on the birth certificate or may choose not to put the father's name on the birth certificate. And
Mhm.
so, in a case where, for instance, they've had children and the name of the father is not on the birth certificate, it makes it very difficult later on when they have broken up or they have separated, that the other parent will have any access to the child or will have any contact with the child. And so it makes it very, very crucial that whenever two people come together and they decide to have children, that everything that they have worked for in terms of bringing up these children has to also show in terms of their names being put on the birth certificate as well. But thank goodness that even if your name is not on the birth certificate, there are ways to go about it as well.
Right. So, child arrangement order, you've given us the definition. You have identified for us who could be a party to the child arrangement order. Is it always the case that we have to go to court to get that arrangement put in place?
Not necessarily, no. And the court advocates for parties to obviously try mediation before coming to the court. And it's necessary because we all see the family unit as a place where we are able to build up the children as parents, and then the children are also able to grow and add to the community or add some sort of value to the world in which they live in. And so when you think of the family unit, you think about how the community flourishes from the inside out. So if for any reason two people are not getting on, it is no fault of the child that those two people are not getting on. And so the court would prefer that the two people work things out informally
Mhm.
before they come to the court. And so at best, they say try mediation, see how it works out. If you're able to come to an agreement through mediation, then that's even better because the children need the two of you to agree in order that they too may be able to have a safe haven that they call home. And so the court is always advocating that mediation should be a way of parents coming to a resolution before they come to the court. And before you even fill in a form to go to the court, you must have the mediator sign that you have tried mediation before the court can accept your form C100.
Okay.
Yes.
So there, I see two parties at loggerheads. There's a mediator who probably may be the head of the family, a member of or an elder of your church or the pastor, a very significant person in the lives of the family. Now, they have sat down, they have agreed on whatever there is that they have to agree on. When they have done that, would the verbal agreement hold? Or when they would have done that, they will have to put something on paper and send to court and say that we have this arrangement and we want the court to endorse it.
Okay, so in a case where there's an informal arrangement by, let's say, a spiritual leader or a church pastor, or let's say an elder within the family unit, if the two parties have agreed on something, we would always say that it is good to have it in a binding effect so that nobody says, oh, well, it was just something that maybe the elder agreed on or the pastor agreed on, so we don't have to do much. The court can also give its, should I say, permission and stamp it to say that this is a binding agreement between the two parties. And most people, if they can't find somebody neutral that they agree with, they would try a MIAM. So a MIAM is usually mediation information and assessment meeting, and that is by a qualified family mediator. So with qualified family mediators, unfortunately, they are not free, so they will charge you a fee if they are to mediate between the two of you. And whatever agreement the two of you come up with the mediation services, they will also let the court rubber stamp it, and then we know that the agreement is binding on the two of you. and everything that has been said or stated will have to be, should I say, agreed upon and then worked out between the two parties who are, to say, taking care of this child. Yes.
I am thinking of a situation where I wanted to go to the duration of the agreement, but I'm thinking of a situation where a member of the community finds that couple A, man and woman, or the parent, do not really see eye to eye with each other, and the child is at the suffering end. So they come in to say, well, like maybe a local authority would become a corporate parent of that child. Can an individual say, I'm going for a child arrangement order because I see that these people cannot really properly take care of this young person, and the interest of the young person is what is paramount to me? Can an outside person go in there and ask the court to give them a child arrangement order and take them away from a parent or a set of a couple that are not capable of taking care of this child?
I mean, in a scenario where the council, for instance, has realized that both parents are incapable of taking
Mhm,
care of this child, they would usually look to see if there are other relatives who can take this place.
mhm,
And if there are no other relatives, maybe a family friend or some sort of guardian who can take that place. Maybe it could be that both parents are under drug abuse. It could be that one parent is negligent, the other parent hasn't even played a role in the child's life since the child was born. It could be for many reasons.
mhm.
And so if the local authority comes in and realizes that, hey, this child is being neglected, parents cannot take care of this child, we want to take the child into our care, but then we realize that there is this family friend or there is this family member who has volunteered to take care of this child. Then during court proceedings, the local authority will let the court know that there is this other person who we believe should be able to take care of this child. And if that person is not a relative, then they would let the court grant them a special guardianship order
Order.
in
Okay.
which they would use to care for that child because that person is not a family member or a relative to that child. Yes.
All right. So then I would ask if an arrangement is made and is made an order, how long does it have to stay for? Um, does it become obsolete when the child turns 18?
So usually we say that when the child turns 18, that special guardianship order or that child arrangement order will no longer be enforceable because when it comes to um, what the law states a child is, the law is usually clear that it is any person under the age of 18. And there are cases or scenarios where when a child is 16 or over, we would say, okay, they have the right to buy certain things from the shops, or they even have the right to get married in some circumstances. So, when the child really turns 18, it is deemed under the law that they are now an adult.
Mhm.
They can choose where they live, they can choose, obviously, whom they relate with, and the rest of it. And so, once a child turns 18, they are no longer bound by the child arrangement order or the special guardianship order, and they are free to live their life the way they want if they choose to live it independently.
Right. Well, we're looking at the initial and the definitional issues and some of the bits and pieces of the arrangement order. The arrangement order in itself, Eunice, is in the interest of the child. Do they have a say in that?
Usually, if a child is of age, and they would usually say that a child that is above the age of 8, usually um, when a child is even 12 and above, they will consider the Kafkas. So, Kafkas is the, should I say, social worker that the court would usually ask to assess the needs of the child and how they relate with the parent who is seeking for a child arraignment order. And so Kafkas would usually take into consideration the child's point of view, especially when they are above the age of 12 and above, because as soon as the child reaches that age, most children at that age would usually have a sense of who they would want to be with, why they would want to be with that parent, and how best they would have their needs met if they were with that specific parent. It may be that they want to spend time with both and they don't want to be with one particular parent per se. So the opinions of a child who is over the age of 12 or 12 and above is highly considered. I wouldn't say that their view is the only view that is taken by the court, but they will consider their views very strongly. And it is because they know that those children are capable of making certain decisions and are matured enough to know what they want from both parents. Usually, when the child is very young, it will be up to the courts to make those decisions in the child's best interest, like you're saying. And they will consider certain factors as well in terms of whether the child is able to have their physical needs met, their educational needs met, even their spiritual needs met, and how capable the parent who is looking after them is able to meet those needs, and whether the parent who is also seeking child arrangement is able to meet those needs of the child. And so they have to consider certain factors when it comes to who is best placed with the child. And if both parents should have contact with the child, how those needs would be met by both parties as well.
This order that we're talking about, child arrangement order, how often can it be reviewed? Or once it's in
As
place, it's laid, it's set in stone?
As it is, usually the court expects that it will be abided by until the child is 18. But unfortunately, um, some parents or some parties are unable to comply with what is in there. And
Mhm.
so, if for any reason one parent is not adhering to what has been stated in there, then the other parent can definitely go back to the court and say, hey, this was what was agreed. This other parent has decided to do A, B, C, D, for instance, has decided to say they're taking the child out of the country and they don't want to live in the UK anymore. I don't agree with that. I want the court to um, stop this person, prohibit this person from taking the child, and I want this person to comply with whatever was stated in the rules. And so, if for any reason any issues are to arise, the other parent can apply to the court for some sort of enforcement of the order or to prohibit the other parent from taking certain steps as well. So, yes, it can be reviewed when the issue arises.
All right. If you just joined us, we're live on BWTV and we are doing this courtesy BWF Solicitors. We're live at BWF Solicitors and at BWTV, both on Facebook and YouTube. You can join us via your text on 7399208468, or you can send your comments and questions in the comment section down below, either on Facebook and or YouTube. This afternoon, we're looking at child arrangement order. The main question, we haven't really come to that. We'll be doing that. We're asking whether a parent who is not listed on the child's birth certificate can apply for child arrangement order. We'll be looking at that when we come back from the break to say thank you to BWF Solicitors. BWF Solicitors is located on the fourth floor of the other house, 214 to 218 Tottenham High Road, Seven Sisters in North London. If you're driving, the postcode is N15 4NP. If you're going by public transport, you get on the Victoria line to Seven Sisters, I should say, and then use exit number 2. That brings you to the frontage of the Anna House. Climb to the fourth floor, as where you find BWF Solicitors. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Call them, book an appointment, come see any of the lawyers. A big, very legal, astute family, and they will respond to you and help you through your journey. 0208 493 7340. 0208 493 7340. If you're in Ghana, call the office line on 055 589 5959. 055 589 5959. In emergency situations and at all times, just call the UK number or text or send a WhatsApp to 077 127 61884. 077 127 61884. BWF Solicitors brings us the community and the law every Saturday afternoon between 4 and 6. Let's say thank you to BWF Solicitors now, and when we come back, we continue with the discussion.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. I am delighted to say that we have lawyer Eunice Champon, partner of BWF Solicitors, with us, and we're going through the topic, can a parent who's not listed on the child's birth certificate be a part of a child arrangement order. She has graciously taken us through the technicalities of what a child arrangement order is, how it's done, what the court does, the mediation process, and all the rest of it. And then we have looked at the duration of that, how often can it be reviewed, and all the rest of it. If you have any questions, put them in the comment section down below or send them to our WhatsApp number or text number 07399 208 468. When the lines are active, I will announce them, and then you can call in and ask Lawyer Eunice any legal question that you have. Now, Eunice, back to you again. Our topic says, can a parent who is not listed on a child's birth certificate apply for child arrangement order? Now, when we're talking about who a parent is, there are the technical definitions, there are the natural parents, the mother and father. We're talking about stepfathers, we're talking about stepmothers, guardians, and the rest of it. Help us define a parent, and then we come and link it to the topic we are discussing.
Okay. So usually a parent will be any person who by biology would say has a child who is under the age of 18. So usually a parent will be the biological, should I say, bearers of a child. But in this case, where, for instance, we know that a parent has um, lived with a child for a period of time, and then for some reason, they may not be listed on the child's birth certificate. It may not necessarily mean that they are still not a parent. It's one way of evidencing that they have parental responsibility for a child, but it does not necessarily mean that they will not be seen to be a parent if they are not on the birth certificate, or if they were not, for instance, married to the other parent. So most people will agree with me that anyone who has biologically had a child will be seen to be a parent. And I think that's the understanding that most of us would have.
Well, I am looking at a parent who may not have their name on the birth certificate as a stepfather or a legal guardian, one way or the
Mm.
other. Can they, one, initiate the arrangement order, or can they really be a party to that? For instance, a stepfather finds out that no, my stepchild is being maltreated. We don't have that cohesion or understanding between us, and I'm going my way. But I feel that this child would need my support, would need my love, would need my parental guidance. So then I go into into that process or get an order
Mm.
so that I can have the child under my guidance and I make decisions for this child. But then the
Mm.
mother would say, no, 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 I brought this child into this relationship. So it is
Mm.
my child.
Mm.
In this case, can the stepfather be a party or even apply for that?
Mm. It's good that you asked that question, because you have, should I say, mixed families where the man who has now become the stepfather has gotten married to the lady who already had a child, and the both of them have their own children together, but maybe the eldest child or the eldest two children are not his, but they all know him as daddy, and so they've all become a blended family unit. And so in that case where there's that blended family unit, and then all of a sudden there's a separation, the children are used to this one male role model,
Mhm.
and they can't see themselves not having their father around. And in that case, if the father, who is the stepfather, is saying, do you know what, I still want contact with these children, I want to be able to have the direct relationship that I have with my own children, with my stepchildren as well, he can definitely apply to the court to say, I want parental responsibility for these children. Maybe things didn't work out between me and their mom, but I'm applying to the court to grant me that parental responsibility so that I can also have these children be a part of my life. And under Section 4 of the Children's Act 1989, you can go about to apply for parental responsibility if, for instance, there has been an agreement between the two parties, which is the other parent and this step parent, that they can go ahead and play that parental role in the child's life. Or the court can go ahead and then give that order to the step parent to go ahead and have parental responsibility for those children as well.
So
Yeah.
even if uh, the birth parent does not agree, the court can then even order in the interest of the child.
If the birth parent, let's say the mother of the children, says, "Do you know what? I don't want him to play any role in these children's life." The mere fact that they were married, and maybe they may still be married, but they may just have separated, they the court can look at the fact that these uh, children have had this step parent in their lives for the past, let's say, 8 years, and therefore, by reason of the fact that the parents are married to the children, this stepfather is still a father, and therefore we should be able to give parental responsibility to this step parent because he was married and he has lived with the children as if they were his. And so, by reason of just the fact that they were married as well, the court can go ahead to grant this step parent that parental responsibility just because they've been a family unit for however long they've been a family unit for. Yeah.
So we looked at the criteria where the person who is not their birth parent or may not even have their name on the birth certificate is given the right to do that because they play a role in the life of the children. Is that the only criteria, or there could be other factors that can qualify a person whose name is not on the birth certificate to be a part of that arrangement?
There are situations where even the biological parent may not even be on the birth certificate.
Mm.
And so, in cases like that, if the birth parent himself is not on the birth certificate, they can also apply to the court for the court to give them a parental responsibility order to say that they are indeed the father to the child. And then obviously, we know that when it comes to other scenarios where there are other family members, then obviously the court will grant as part of the child arrangement order a parental responsibility order as well, just so that these other family members who may not necessarily be the father or the mother to the child may also have that parental responsibility to make decisions on or on behalf of the child or for the child as well. So there are those scenarios where other people who are relatives or family members may also be given that parental responsibility for the child as well.
You mentioned earlier on that um, the court can ask the parties to go into mediation, have their own informal arrangements, agree between themselves, and then the order could be certified by the court or granted. Or they may even decide that, well, we have had mediation, we have done this, that, we have agreed upon these things and abide by them. Now, when this person whose name is not on the birth certificate is trying to have an arrangement to take care of her children, Can that informal process hold? Or in that situation where the person is not on the birth certificate, it only has to be a court order?
I mean, most of the time, the only reason why somebody may not be listed on the birth certificate is because him and the other parent have had some misunderstandings, and
Mm.
the other parent is not willing to come to an agreement with them.
Okay.
And that is one of the reasons why they are not on the birth certificate in the first place. And
Mm.
so, most likely, they are not going to be able to agree in mediation anyway. So it is more likely that they will have to resort to the courts as a last means of resolution. And so when it comes to parents who may not be listed on the birth certificate, it becomes necessary to also let the court know that yes, maybe we are loggerheads, but we've tried mediation because the court says we have to try it anyway before we come to the court. We've tried it and there's no way we can come to an
Mm.
agreement. And so we want the court to put an order in place in which we can both go ahead and agree that um, this is what we are after, and we want the child's best interest to be made paramount so that they can have both parents in their lives. And so, in most cases, the court is the only way they can get through
Mm.
to getting an agreement so that they can move forward.
So let's say this child in question is 10 years. And we know that when they turn 18, they can take their own decisions and also decide what they want to do. 2 years into the agreement, this stepfather or this person who does not have their name on the birth certificates thinks that I've had enough. I wouldn't be able to continue with the kind of arrangement that we have had between the two of us. The court may have endorsed it one way or the other. Can anybody pull out within that period at any point in time?
I think it's the reality that most of the time, if for instance, um, it's not the order that's the issue, but as human beings, we have our downfalls, and we may decide to not agree or disagree in terms of arrangements that have been put in place. And if that should happen, it is no fault of the child. And if both parents are unable to agree, and of course, we don't want the child to be in the middle of any form of disagreements that the parents may have, one parent may choose to withdraw and say, do you know what, I've had enough. I'm no longer willing to push for what has been agreed, even though maybe I may have the right to see my child on weekends and during holiday periods. Unfortunately, the other parent hasn't been able to comply, and I'm just fed up of always trying to find out why the child can't spend weekends or vacations with me. And therefore, I've decided I'm no longer willing to fight. I will back down, and when the child is of age, they can come and look for me. It is what it is in reality. Some people may go ahead and enforce it because the child would usually want the other parent to fight if they're old enough. They'll say, why is it that I don't see you anymore? Why don't you come and get me? I don't want to be just with this other parent. And in that case, the parent who might be the step parent or the father may apply to the court for an enforcement order. But if obviously the child is okay with the arrangement of both parents, and then they tell the other parent, do you know what? We can still communicate, we can still do the things that we do, even though you're not coming over. I will still see you after school, or I'll still meet up with you. Maybe the other parent doesn't have to know, and all the sorts. So the reality is, yes, the other parent can choose to withdraw or back down, and nothing would happen if that happens. It is only if the other parent seeks to have an enforcement order from the court that the court will go on to make sure that the child arrangement order that was in place before is enforced. Yes.
We expect that the family can stay together and in harmony bring out the children. But if things go southwards, if things turn pear shaped and things are not working, the children do not have to suffer. And that's why in law there is a child arrangement order. It's an arrangement between the parties as to how they take responsibility of children. Initial informal arrangements could be put in place. You can go through mediation, and you can also send that arrangement to the court to endorse, or the court can give the order and say, A takes care of that, B takes care of the other. And we have also looked at the question where we asked, can a parent who is not listed on the child's birth certificate apply for child arrangement order? The answer straight away is yes, but there are ways of going around it. Um, by way of trying to understand the law, let me ask, if we go into a child arrangement order, are there particular steps to follow? What do we need to do between ourselves and probably with the involvement of a third party and the court? How do we start and how does the agreement come in place and it starts working? Maybe there's some steps that we can follow, so we don't, when we have to go through that, we don't skip any.
Okay, so in order to apply to the court for a child arraignment order, both parties, like I said before, have to go under MIAM, which is Mediation Information Assessment Meeting, and they have to do so, and the mediator will have to certify that they have tried mediation and it didn't work out, and that's why they are applying to the court for a court order. And so once they've been signed off by the mediator, they will complete the C100 form, and you will pay a court fee when you are submitting your C100 to the court. Usually, a C100 form will go together with a position statement which tells the background of the matter, why you are seeking a child arrangement order, and what you want the court to put in place in terms of the child arrangement order. And if you have any evidence to go with it, you can do so by adding that to your statement as well. The court will go ahead and then asks you to also serve on the other party, or the court can also serve the other party with any form of documentation to show that you have applied to the court for a child arrangement order, and therefore this is what the court is willing to agree in terms of a hearing date, for instance. And then if you have any refutes in terms of the things that have been stated in the statement of the other party, then you can go ahead and respond to those statements that have been sent to you as well. Once, obviously, the other party has been made aware, Kafkas, who are the social workers that work with the court, will also be asked to assess the children or the child and the parent. And so they will usually interview both parents and then the child. And if the child is usually underage, maybe very young, then the child will be interviewed together with the parent they live with, to just find out certain things in regards to how the child relates to that parent, how the child is able to relate to the other parent, and if there has been any form of domestic abuse whatsoever in the past. Once Kafkast has basically done their assessment, they will come up with their report, and their report will be given to the court. The court will use this as a basis when making their decision as to who will have contact with the child. And in most cases, there will be hearings. And depending on how cooperative the parents are, there can be hearings throughout the year. Some parents are not very cooperative, and so um, sometimes they may not even appear in court, and that will end up prolonging the whole process. And so, in most cases, if it's not a solicitor attending court, it will be a barrister, and you will have to pay for the fees of the legal representative who is going with you to court. And so that would mean that you are having to spend money, you are having to take time off work, and the case may be ongoing for sometimes even 2 years or more, depending on how cooperative the other parent is. And so by the end of, you trying to get a child arrangement order, both parents should have come to an agreement. And if one parent is proven difficult, then the court will still go ahead to put an order in place, and they will expect both parties to comply with the order anyway. And both parties will be given copies of the order by the court, and they would expect that they would agree to what has been stated in there until the child is of age. And so, yes, that is just a summary of how the court will go about dealing with a child arrangement order, which
I guess I will play it safe as I do all the time to say that when it comes to matters like this, the mediators or speak to your lawyer and let them help you understand the processes and also go through it correctly so that you don't fall foul of the law. But it's in the interest of the child. Let's try to get matters resolved as quickly as possible so our children will be safe. If you just joined us or you have been listening to us, we've been talking about the fact that child arrangement orders are there. And we asked the question whether a parent who's not listed on the child's birth certificate can apply for a child arrangement order. The answer is yes. We have gone through what the definitional issues are. We've looked at the processes and the implications of that. You have any question, you can send that to our comment section on Facebook and YouTube at BWF Solicitors and at BWTV UK, or you can send it to our text number 07399208468, or the lines I think are active now. Yes, I'm ready to pick them up. 0208-493-7345 right after this. Let's look at our social media handles so you are conversant with that. Yes, you're still live with us on BWTV at BWF Solicitors on Facebook and YouTube, and at BWTV on Facebook and YouTube. You can join us live in the studio 0208 493 7345, or send a WhatsApp or a text to 07399208 There it is. We went off to show our social media handles. But before we went away, Sandra Fraser came up with a very interesting question. And she says, what if the child is a special child who cannot make decisions themselves? For instance, they get to 18 and there is a child arrangement order in place, but a special child can make decisions for themselves. Can you continue beyond that?
Obviously, once a child grows and is 18, there's soon to be an adult. And I think usually children with special needs, autistic children, learning disability, you have all these categories that they put children who have special needs. And so we don't term them as disabled, we call their needs special. And so if these children are not able to make a decision for themselves because they may have some sort of special needs and they can't agree or they can't give their opinion as to which parent they can reside with, then as it is under Section 1 of the Children's Act, the court always has the child's best interest at heart, and they have to consider the child's physical well-being, the emotional well-being of the child's age, the child's sex, the child's health conditions, and everything that makes up this child, and which parent is the best parent, or are both parents likely to meet those needs of the child. And so, if, for instance, you have a child who is very much on the high end of the autistic spectrum, and for instance, they are very strong, and it's the dad who can deal with that, then the child is more likely to be suited with a parent who can deal with him or her physically, because unfortunately not every mother will be as should I say physically capable of taking care of that child, for instance. And so all the needs of the child have to be considered by the court, including the physical needs of the child and the health conditions of that child, and who is best capable of looking after those needs as well. And so, yes, in a scenario like that, where the child may not be able to give their opinion, the court will go ahead to look at all those needs that the child may have and which parent is best suited to meet those needs. Yeah.
Well, you can keep sending your comments and questions through. We will pick them on the various platforms, or you can also call in 0208 493 7345. Are there other agencies or companies employed by the Home Office to carry out immigration raids or check? SECO and G4S, do they work for the Home Office? Do they carry out immigration raids or check? Serco was spotted outside London at a local shopping center with a van that looks like a police van, but labeled Serco with tiny windows. Staff got out of the van and instructed by a leader to enter some specific shops. They're dressed in blue uniforms with IDs hanging around their necks. Could they be working for the Home Office, Lawyer Yunus?
I mean, I like this question because obviously the Home Office can, should I say, have the services of third parties work for them, just like we have with the biometrics. I mean, the biometrics are not by the Home Office themselves. They have obviously contracted a third party to carry out the biometrics of applicants who apply to the Home Office for any leave to remain or any sort of should I say immigration status in the UK, for instance. So yes, the Home Office can outsource some of their duties out to third parties. Um, they can choose whichever companies they wish to outsource some of their duties to. And we know that the immigration hand of the Home Office has an enforcement agency as well. And that enforcement agency may choose to outsource their duties to another company to do so. And it may be that G4S may be working in compliance with Home Office to carry out certain duties. And we all know that when it comes to illegal immigrants, the Home Office do take that seriously. And where they believe that there may be illegal immigrants working or obviously staying, they are likely to raid those places to make sure that they are enforcing immigration laws as best as possible. Yes.
Okay. Let's pick up some of the comments. As I said, you can bring them on our Facebook page, a YouTube page, send them as a text message or WhatsApp message. Now, this one is from somebody who says applying outside of the UK from Bangladesh. And the person says, I applied for a UK skill visa on 20th July and attended by my match appointment on the 31st of August. As of 18th January, I've not received any update. I've sent 3 paid inquiries. UKVI replied to the first paid inquiry and said they would update me within 20 working days. But I did not receive any further response. I did not receive any reply to the second and third inquiries. Linus, the person goes on to say, after my last call to the UKVI, they provided me with a new email address and advised me to see my details, to send my details by email. Sorry. However, as of 18 January, there's still no update, no request for additional documents, no interviews, no decisions. Please kindly advise. What do I do?
It's amazing that it's taking this long, and I don't know why the person had to pay to make inquiries because the person is in the UK and I've never heard those in the UK paying for inquiries. I know that usually if you're outside the UK, maybe you might have to pay for the telephone call or you might have to pay to send certain inquiries. But if you are in the UK, I've never heard of paid inquiries. So I'm very interested to know what kind of paid inquiries he's referring to. Usually, if you have to make a complaint to the Home Office, you do so online using their online form. And I know that once you've made a complaint using the online complaint form, they will respond to you within 20 working days. And that's the online complaint form to the Home Office. They also have the pre-action protocol that most legal representatives can obviously go ahead and request on your behalf. So if you have a legal representative obviously dealing with your matter, they would usually respond to that even quicker than the complaint, which is 20 working days. And so with the pre-action protocol, they are more likely to respond as soon as possible, at least within 2 weeks of receiving your complaint. So it's very, very key to get your legal representative to also do a pre-action protocol to the Home Office to see where they're at and why they haven't responded to you within the usual time frame, because skilled worker visas usually take a few weeks to decide. I think it's about 8 weeks. So to take this long, I think obviously you need to make sure that you are using the right handles rather than calls. I always have an issue when it comes to people saying, "Oh, but we called the Home Office and they said this and that," and I'm thinking that is a call center. That is not the Home Office. So calls are not very effective. Using your written skills, especially when it comes to the complaints procedure or going through a pre-action protocol, uh, is best in terms of getting a response if it has gone way past the processing time. And in this case, it is usually upset to hear that the skilled worker visa has taken over 6 months to decide. So definitely get your legal representative to do a pre-action protocol so that you can get a response as soon as possible.
Well, often say that, and Lawyer Eunice has just reiterated it's always best for the layman to give their work for an artisan to do for them. So speak to your lawyer, speak to your legal representative, and get them to do the right things for you. I can recommend that you speak to BWF solicitors, and they will help you. Please, a father has direct access to a biological child with his ex-partner. The ex-partner has another child from different relationship who has no contact with his father at all and never known his father. So the man sees both children without discrimination. He treats them equally, assumes parental responsibility for the non-biological child as well. Lawyer, the child knows this man as father and he doesn't know his father. You take him to school, hospital, mosque. If the mother agrees, can a child arrangement order be granted to the man based on the child who is not his biological child? If granted, can both children be used to apply for leave as both are British citizens? Can the man consent for all things in the non biological child's life? That's a multi faceted question that Nadetia has brought.
Okay, so the first one has to do with whether both children can be used to apply for leave to remain. And then the second question has to do with can the non biological parent consent to everything in regards to the child? When it comes to immigration issues, I know that most parents who may not have immigration status may seek to rely on their child arrangement order to make an application to the Home Office in regards to the fact that they have contact with the child.
Mhm.
When it comes to those parents who would want to use that child arrangement order as part of their supporting documents for an immigration matter, it's not something that is by law, but it is under our procedural rules that when it comes to disclosing family issues to third parties, that the parent in question has to seek the permission of the court in order to disclose any court order or any court proceedings with a third party. So, a third party can be the Home Office because they were not party to the court proceedings when you were getting your child arrangement order. And therefore, if you want to use some form of child arrangement order in your immigration application, you would first need the permission of the court to disclose the order to the Home Office per se. If the court gives you permission, then you can go ahead and use that court order in an immigration matter. And like I was explaining before, if you're a step parent and you are living together with the other parent as a married couple, yes, you can apply to the court for parental responsibility order in order to say that yes, even though this child is not your child, you are applying to the court for a parental responsibility order and a child arraignment order, even though the child has no relationship with the biological parent per se. And the court will look at the circumstances of each case and will make their decision. And when it comes to making decisions on behalf of this child, then of course, decisions to do with their health, their education, where they live, all those important decisions can be made by you and the child's biological parent who you are married to. So it's a good thing if you want to go ahead to apply for a child arrangement order because the biological parent does not play any role whatsoever in the child's life. That can be applied for under Section 8 of the Children's Act of 1989.
Thank you, lawyer, for that. Keep them coming through 0739920848. The lines are active 0208 or you can leave them in the comment section down below as people have done. I have a family member in Ghana, lawyer, who is having a lot of financial difficulties in catering for their three children. I want to help out. I want to formally adopt one of their daughters. What is the correct process of going about this? I am a British citizen.
I mean, whenever I see these questions, I ask myself, so if, for instance, you went to meet somebody and they had so many children, by your standards, because the person has too many children they are unable to look after, does it become your responsibility to take one of them? Well, based on each person's moral perspective, um, everyone will have their answer. But by law, unfortunately, you cannot adopt a child whose parents are still alive. So, if the parents of the child are still alive, unfortunately, that child is not a child you can adopt. You can do so if the parents maybe are deceased, are completely incapable of taking care of the child, and or if they have abandoned the child completely, then you can say that you are going ahead to apply for an adoption order where the child is under the age of 18. And so when it comes to adoption, it is not possible to do so if both parents are in the child's life or even if one parent is in the child's life. You can only do so in the scenarios that I have explained.
Anaya, you mentioned that if the parents are incapable, if I'm able to prove to the authorities as a part of my application that these parents are incapable of taking care of this child, can't I still go ahead?
So to prove that a parent is incapable, usually you will have to have some strong evidence to back what you're saying. And in most cases, if the parents are incapable, the children are more likely to be on the streets or to be in the hands of social welfare, for instance. So if the parents are incapable, this could be to health reasons. It could be that they may have mental illnesses, they may have health conditions that have rendered them incapable of looking after the child. If that is so, then obviously the social services would definitely need to get involved. They would need to assess the situation. And if it is so, they will inform the court that unfortunately the parents are incapable of looking after the child, and this is the evidence to obviously substantiate what the claim is. And so it is not just by way of mouth, you have to have evidence to back whatever you're saying. And if that is correct, then if you are a family member, then you may be able to get the court to grant you an adoption order per se. Or if you are an outsider and you have just realized this child on the street and you have involved the social services, for instance, and they've come to the agreement that there's nobody to look after this child, you can go ahead and apply to the court for an adoption order if the child is seen to be a child without a parent or parents in this scenario.
So in this case, to be able to do that, obviously the social workers or social services, say in the country you're referring to, would have to be involved before the court can grant an order, and their evidence
Yes,
will have to be strong.
yes, definitely. You can't go about and say that you know this child and you know that the child's parent is incapable of looking after the child. You want the court to go ahead to give you an order. Unfortunately, there has to be some form of procedure, and in most countries there will be some form of social welfare or social services that you will need to contact, or some form of agency that you will need to inform before you can go ahead to apply for an adoption order per se.
I assume this will be a very expensive venture, isn't it?
Definitely. Obviously, going through the assessments with the social services or whichever agency that you need to go through, you would be spending quite a lot of money going back and forth, for instance, and then making those applications to the court and paying legal representatives to represent you. All of that will count towards the cost. And in this case, obviously, we don't know which country. I know that Ghana used to be on the list of countries where adoptions were considered safe. It's no longer on that list. So even an adoption order from Ghana could be in question as well. But when it comes to getting a custody order is usually an order given by an authorized court and a competent court. And so a custody order may be granted to a relative or a family member of that child whose parents may be incapable of looking after them as well.
Well, I guess this person may want to sit down with the qualified lawyer or speak to BWF solicitors and get some directions, because it's not something you can just think on the top of your head that you can do so easily. Well, earlier on, I mentioned that we needed to look at some situation where we found ourselves getting our friend ER asking us a question for advice. The Secretary of State, as we said, has the power to certify asylum on human rights claims as clearly unfounded, meaning they lack merit, thereby preventing the claimant from bringing an appeal while still in the UK and enabling quicker removal. This certification can happen if the claimant is from a country listed as safe, that is a designated state, or on a case by case basis where the claim is deemed factually unfounded, often leading to an appeal only after leaving the UK or through a judicial review. This is from Section 94 of the Nationality, Immigration and Asylum Act of 2002. We had the explanation from Lawyer Eunice, and then I brought in my question, and it was about our friend Yababy, who is an overstayer in the UK. She made a private live application on the grounds that leaving the UK will bring her hardship in her home country, even though she has not lived in the UK for 20 years. Application was refused and certified. Let's advise here. Are we going to say to her, yeah, you open to removal from the UK, therefore apply to leave voluntarily? Is it number two, yeah, can seek judicial review to challenge the refusal decision? Is it three, yeah, cannot appeal because her refusal decision has been certified? Or none of the above? Think of this. I'm taking a quick break, and when we come back, I will ask Lawyer Eunice to help us unravel these and see which of the options is the best advice to give to you. It's still the community, and the law is brought to you by BWF Solicitors, a trusted partners when it comes to the law. The community and the law is still live. We're live on BWTV at BWF Solicitors, Facebook, YouTube, at BWTV, Facebook, and YouTube. Now, Eunice, Yababy's problem is here. Before I let you come in, let's see what answers I have had. Mami Sewa says it's number two. Thank you, Mami Sewa. We'll look at that. Then the other one is from Francisca Boateng, says number two, yeah, can seek judicial review to challenge the refusal decision. Okay, so let's see. Maxwell Smith also says it's number two. But see, two seems to be a very popular answer. Mavis Boateng, yeah, can seek judicial review to challenge the refusal decision. Kamyasari also comes in and says, well, it's number two. I'm reading that on the screen. Kamyasari says number three. Sorry, yeah, cannot appeal because her refusal decision has been certified. Next one here, Clement Osei is saying number one, yeah, is open to removal from the UK. Therefore, she can leave voluntarily. Kofi Arthur says it's number three. She cannot appeal because her refusal decision has been certified. Well, Abner Newton, all of the above. Next, we have and Yasewa Ya can seek judicial review to challenge the refusal decision. Tilly Dumas says is number two. Ya can seek judicial review to challenge the refusal decision. Thank you, Tilly. Next one is from Anita Ousu, number four. The next one we have is from Mamboatma. Mamboatma says yeah, is open to removal from the UK, therefore she can leave voluntarily. That's number one. Kojo Boatin says number three. Thank you, Kojo. And I'll pick the last one, then I'll go over to Lawyer Eunice to help us with that. Eric Kubi is none of the above or all of the above. Lawyer Eunice, proper advice. Let's come to you.
Okay, so this is one that has really tested our viewers because when it comes to Yababy, she's obviously made a private life application where she thinks that she can reside in the UK, and unfortunately, it was refused. And like I was saying, when it comes to either protection claims or human right claims, the Secretary of State can certify the decision to be unfounded. So that means that obviously the claim that Yeah Baby is making about her life being facing hardship if she were to return to her country of origin is going to be one which she has to prove that is true and is genuine. If she cannot prove that her claim that she will face hardship or fear of persecution is true, then of course she has no claim and it will be certified by the Secretary of State. So we have the option, yeah, is open to removal from the UK, therefore she can leave voluntarily. Based on Section 94, her right of appeal is removed, and so the Home Office will let her know that she doesn't have a right of appeal, and therefore she's liable to be removed from the UK. Obviously, if she is looking to leave the UK voluntarily, she can leave the UK voluntarily as and when the decision arrives. We spoke about judicial review, and in that case, if she believes that she has all the evidence to show that her claim is genuine and that her claim is well founded in that there is real persecution if she were to return to her country of origin, then she can go ahead and challenge the decision by way of judicial review. Of course, we know that under Section 94, her right of appeal will be removed or is removed because the Home Secretary has certified it as unfounded, and so that is an obvious one. So we can say four is the should I say the answer to the question. If she's able to obviously go ahead to show that she has real grounds for being in fear of her life, then yes, of course, she can go ahead with judicial review. She has no right of appeal, as we said, under Section 94, and she is likely to be removed if she has she has had her claim certified under Section 94 of the Nationality, Immigration and Asylum Act of 2002. So yes.
So yeah, baby, there you go. You you are open to all four. As you have your private life application that has been refused and the decision certified, you cannot appeal the decision. You can choose to leave the UK. You can choose to seek the judicial review, as lawyer has mentioned, to challenge the decision in court. And this is premised on Section 94 of the Nationality, Immigration and Asylum Act of 2002. I think there were just a few people that selected number four. Um, one, two, and three, yes, but they all come together. That's why we said all of the four. Thank you very much, Mara Eunice. And as tradition demands, what did we talk about this evening? Maybe your summary can remind us.
Yes, so our topic today was to do with whether a parent who has not been listed on the birth certificate can apply for a child arrangement order. And yes, of course, a parent who has not been listed on the birth certificate can apply to the court for a child arrangement order if, for any reason, they are unable to come to an informal agreement and mediation has not worked for both parties. they can seek a child arrangement order from the court in order to have contact with the child. And usually, if the child is permanently residing with the other parent and they want contact with the child, by way of applying to the court for a child arrangement order, the court will also look to the child's best interest as being paramount. They will look at the needs of the child, and they will then look at how capable those needs are being met or are to be met by either of those parents. If the parent applies to the court for parental responsibility because they are not listed on the child's birth certificate, the parent is likely to be granted an order if they can show that there is an agreement between the mother or the other parent that they are indeed a parent of the child. In some cases, maybe not all cases, the biological parent may not be listed, and therefore, by way of a DNA, they can prove that they are the parent of the child. If it is a step parent who is married to the child's mother and the biological parent hasn't played any role in the child's life, they too can also seek to apply to the court for a child arrangement order as well. Once a child arrangement order has been granted, the arrangement is enforced until the child turns 18. Otherwise, if the parent or both parents do not comply with the child arrangement order, the other parent can seek enforcement action in terms of compliance with the child arrangement order. This is briefly a summary of what we discussed today. If you do have any issues or you have any questions, please do seek to phone us and then we can see how best to help you. Our contact details are on your screen. You can contact us on Mondays to Fridays from 9:30 a.m. to 6 p.m.
Lioness, thank you so very much. And we believe that we have had a lot to learn this afternoon. And let me just remind you again, we asked the question, can a parent who's not listed on a child's birth certificate apply for a child arrangement order? The answer is yes. Any further discussions, please speak to BWF solicitors. As Lawyer Eunice has said, the numbers are on the screen. You can call BWF solicitors 0208 493 7340 712761884 is the emergency number. And then you can visit our social media handles and leave a comment. Like we had our friend put in a comment and commended the staff of BWF solicitors and mentioned lawyer Bernard and, of course, Emmanuel Ampiao. It's been another wonderful edition of the community and the law. Let me say thank you so very much once again to lawyer Eunice Champon, partner of BWF Solicitors, for making time this Saturday afternoon to be with us and taking us through that very important topic. And to you out there, I want to say thank you so very much. Without you, we wouldn't have had a show. And for you sticking around this whole 2 hours and, of course, sharing and inviting people to come in and also commenting or sending in your questions. We're so grateful and want to invite you to come again with us on another journey, same time next week. It's been a production made possible by my studio manager, Professor Ade Shilankra Padma Dutu. My name is Ulriku Frimpong. Good evening.